In this video, I'll be discussing the second theory of punishment, which is deterrence. Deterrence as a theory of punishment aims to prevent criminal offenses by discouraging individuals from engaging in criminal behavior. We can identify two forms of deterrence, namely individual or specific deterrence and general deterrence. Individual deterrence is where an individual offender is punished in the expectation that he will not offend again. For example, prison sentences imposed for offenses such as theft will prevent the same offender recommitting such offenses. General deterrence, on the other hand, is where the aim is not just to prevent the individual offender from recommitting the offense, but to discourage the general public from committing such offenses by making an example of those who are punished. For example, higher fines imposed for road traffic offenses will not only prevent the same offender recommitting the offense, but will also generally discourage the public from committing road traffic offenses. These are some of the examples for criminal sanctions that achieve deterrence: license suspension for drunk driving, corporate fines and penalties for environmental damage, mandatory minimum sentences for drug offenses such as illegal trafficking of drugs. So deterrence as a theory of punishment will aim to prevent these offenses being recommitted by the individual offenders as well as by the general public at large. These are some of the advantages of deterrence. It follows a preventative approach, which means the aim of deterrence is to prevent recidivism. So this will help to reduce the crimes in the society, and as a result, there is public protection provided by deterrence. And also it will crack down crimes that society wishes to condone. However, there are some disadvantages of deterrence as well. Deterrence does not follow the rule of law, because when an offender is given a serious punishment to set an example to others, we can look at it as an unequal punishment. So therefore, deterrence does not follow equality, which is required under the rule of law. Also, deterrence relies heavily on publicity. As long as the public is not aware about the offenses happening or the relevant punishments given to the offenders, there will not be any deterrent effect. Therefore, deterrence is relying heavily on publicity. Also, it doesn't work for impulse crimes, crimes that are committed out of pressure or at the spur of the moment. For these crimes, the offenders will not stop and think about the consequences or the punishments that they will get. Therefore, there is no real deterrent effect. Let us see how deterrence has been applied in some cases. In R against Healy in 2002, the defendant was sentenced to 4 years imprisonment for stealing a mobile phone from a 17-year-old. We can see the judge has made a statement referring to deterrence, where he says, "The sentence I pass is to keep the public protected from you and as a deterrent to show that this type of offense will not be tolerated." So we can see clearly how the judges have used this theory of deterrence when awarding criminal sanctions. In our case, Crispin in 2007, Court of Appeal, in an appeal against a sentence of 8 years, was dismissed for possession of a substantial arsenal of weapons, where the Court of Appeal judge expressly held that gun crime was a contemporary curse. The unexplained unlawful possession of such weapons, even if not used, must attract severe deterrent sentences. So these two cases show how deterrence will be applied as a theory of punishments by judges when deciding cases. Thank you for watching the video. I have already discussed retribution in my previous video. If you haven't watched it yet, you can use the below link to watch that video. And I will further discuss rehabilitation, reparation, and restoration in my future videos. Thank you.